Hi, everybody. You probably can't see me, but I'm here in spirit and in voice. This is episode 28 and our year-end review for data in China. And welcome everybody. This episode is going to be a little bit different because we want to make sure that we're getting as much breadth and as much views on this topic because it is an emerging topic, and it's still being fleshed out. So there is a lot of interest in this, and thank you for watching. Just a little bit of housekeeping here. There's not much in terms of slides, but everyone will get a copy of this presentation. But the more important thing is that this is being recorded and will be uploaded to YouTube. When you get, I will send everybody a link to the YouTube video and also a copy of this presentation. And then you could click these links if you have any questions for any of the speakers here. And also our YouTube channel link is right there. We have Mark, of course. The famous Mark is here to talk to lead the panel. We have Atticus Zhao, Sana Duncan from London, and Jerry Wang, also from Shanghai. All of them very experienced in data, and we'll try to get you some different perspectives from not only a China side, but a Gdpr side, and a little bit of compare and contrast. So we have a few topics here for you. And with that said, if you have any questions, just go ahead and put it in the chat. We all can take a look at it, or you can send it to me directly if you prefer that way. And I'll make sure that the question gets asked at the appropriate time. Otherwise, you could just wait for the Q&A at the end too. With that said, go ahead, Mark.
Thanks, Sean. Yeah, so I think today we'll see how well it goes when we just hand things around. But I think the first issue is what we've been seeing in the China marketplace. I think for the last 3 or 4 years, there's been a few trends that have emerged. One was that we saw more and more clients who were digital in nature. So companies that are services or software companies, or companies that are using the internet, or how even traditional companies really integrate digital functions. And that led to, I think, 2 issues. One is the data protection, and that's with the new law, the PIPL, which comes into force on the 1st of November, or came into on 1st of November, and only had a very brief period of time to move to compliance. And I think probably it's fair to say that's where most of the interest and issues have been arising, or inquiries have been about personal data, which was really not really well protected in China. There were some strange cases like the Dun & Bradstreet case, but really anybody who was a consumer in China knew that their data was being used by all kinds of people. And then with apps and the rise of the smartphone, data was really badly protected. And then I think the other issue is cybersecurity, which the law was a bit earlier, but I don't think that's gone away. It just affects less companies. And so I think what we're seeing at the moment is a lot of regulation coming out. And I think it shows that the Chinese authorities are very concerned about, firstly, with cybersecurity, that systems are resilient, so they can't be hacked, that companies are operating in a resilient manner with safe and secure software. And that's been going on for a bit longer, perhaps. And then I think this relatively new thing about personal data, that's really about compliance. And I'll let the panel discuss certain aspects of it. It might not be possible to be 100% compliant because at the moment, we don't really know exactly what people are doing. But I think it's also fair to say certain categories of companies are at higher risk. And then I'll throw it out to the others in a second, or I'll direct some questions. But what's interesting is what we've seen is it's been a flurry of interest, but most of the clients, I'd say 95% of the clients that our small team in Shanghai is dealing with on the data, it's really Chinese companies first and foremost. So Chinese companies are taking it very seriously. And then the second group are German companies. But we've had very few inquiries from American companies or Australian companies. we have a few from other parts of mainland Europe, but I think it kind of shows that European companies are much more concerned about data and privacy than perhaps American companies. But maybe I'll just throw it over to Atticus. Atticus, apart from those kind of big laws and those big topics, you do a lot with autonomous cars and things like that. But there's also like an auto data security law and these things. How do you see the sector interacting? Because I think it's quite complicated. Data, cybersecurity, even state secrets. People kind of put them all together, and they're connected, but they're not so tightly connected.
Yeah, sure. Thanks, Mark. I think in that aspect, I think it's most relevant maybe to the important data, and also you mentioned state secrets. For example, in the auto sector, there's autonomous driving, and the companies have to use the HD map, and during that process, maybe you need to using the map, but it involves the serving and mapping, so that is very sensitive. This is a special area actually, but in terms of the sector's perspective, now if we look at the auto sector, Chinese government, as you may all aware of this, the news that Chinese government is concerning certain automakers the possibility of the sensors to collect all this information, especially those sensitive information. So that's why this year the government issued the sector-based regulation to regulate the data, especially the important data. So basically, regulations restrict the cross-border transfer of important data in the auto sector. I think this may be the trends of the in other sectors. We can expect it that there will be the restrictions on the transfer, especially cross-border transfer of important data. We can discuss this later, on cross-border data session.
So Jerry, since you also joined us from a European law firm recently, what kind of companies do you think were mostly concerned about this? Was it certain sectors are more worried than others? Certain size of companies are more worried, or what kind of, if you're looking for indicators of who is taking it seriously, what kind of companies do you think are taking it seriously?
Yeah, the very obvious answer to your question, Mark, is that if a company is handling or processing external subjects of like personal data, personal information subjects, so this company will be more concentrate on how to ensure their data compliance requirements in each jurisdictions, because they are easily to face with some like complaints or the request for the personal data subjects to how do you say, to satisfy their expectation on the protection of their personal information. So what I see is if there is external data subjects, so these companies will frequently come to us, ask for detailed advice. That's it.
Okay. And so Sana, I think you're the one who's got more experience in dealing with data than everybody else on the panel together, because I think you've been working for 12 years previously at Deutsche Bank's privacy group, I think. So when GDPR came in, was it very difficult for companies? And what do companies think of GDPR now? Do they see it as a burden in Europe, or do they actually see it as a bit of an advantage when it comes to dealing with customers and clients, etc.?
So we've always had, hi everybody, we've always had data protection laws in Europe. Prior to the GDPR, we had the directive. So data protection is not a new concept in Europe. And actually, many of the principles were translated into the GDPR. So certainly those practicing data protection and those companies that took data protection seriously did have some work to do when GDPR came in. But it was mainly the problem with, or the issue for companies with GDPR is suddenly the fines for breaching are now astronomical under the GDPR. So that's why suddenly there was a wake-up call. It wasn't that suddenly, companies had to do something very different. There were a couple of new things introduced in terms of the rights afforded to individuals. You can now ask for your data to be deleted and transferred to other companies, etc. But in general, the main principles stayed the same. So, but also what happened under the GDPR is those principles were unified, or there was a push towards them. The idea is that there should be a unified legislation across Europe. Now, obviously, we've got the UK, which has now exited, so we've got other things happening at the same time in parallel. At the moment, the UK has adopted the GDPR in full. But in terms of, so companies, there was a massive drive in certainly 2017, 2018, where companies started looking at their data protection situation internally and thinking about what measures, if any, they needed to take to up their compliance. Essentially that just, involves a standard audit exercise. So, going through, asking all your different teams to assess what types of data they are holding, what they are using it for, where they are storing it, where they are sending it to, what third parties they might be using, service providers and the like, are there relevant contracts in place? So all those sorts of things people started looking at. And I think a lot of people have got on board with GDPR. And of course, we've seen some really massive fines recently, albeit mainly aimed at the big tech giants, no surprises there, but some really quite surprising things coming out of that.
Okay, great, thanks. So I think one of the things is, which we have this slide, which I don't think anybody can read because it's too small, but I've got it on my phone. So the next point was about the extraterritorial effect. So perhaps Jerry, normally in China, we've often had a lot of clients, especially in the tech space, have been kind of operating offshore because of complexities with VAT licenses or difficulties. A lot of those kind of businesses are restricted to foreign investment. So how is the PIPL law and the cybersecurity law different? How do they apply extraterritorially?
Yes, thanks, Mark. So the concept of extraterritorial might not be new in Europe or perhaps other jurisdictions, but in China, the extraterritoriality of data or cyber-related legal requirements are just formally introduced in China, along with the new promulgation of the new data security law and the PIP, or personal information protecting law, as well as some other draft regulations. So similar to GDPR, that the extraterritorial effects will be triggered when data processing activities outside China is carried out for the purpose of selling products services to Chinese individuals, or they are analyzing or assessing the behaviors of Chinese individuals and organizations, and as well as some other activities they might involve the processing of important data. All these situation will trigger the extraterritorial effect. So as you mentioned, so some of our clients that we were asked by several of our clients several years ago or some years ago that they were asking that they do not have any local presence in China. They are hosting a website outside China while they are collecting the personal information in China. So whether they will be caught by the PRC legal requirements, the answer at that moment was quite ambiguous. So because the law is not clear, but now it's become crystal clear that the answer is yes. And resulting from this effect, so these so-called offshore companies will need to, as required by the PRC regulator, they will need to appoint or arrange the domestic representative department team or individuals in China to deal with the daily compliance matters with the PRC authorities. So this is the big change of this year. Okay,
great. So, I mean, Atticus, how do you see that happening in real life? Do you think, I imagine the law is the law, of course, but if somebody's just got a website and, it's the, some kind of fan club for a, you know, 4th division football team or something, and they're collecting, you know, 30 people's data. It's not going to really trigger anything. What do you think the practical effect of this extraterritorial, you know, measures are? What will really happen? Who will be really affected?
Yeah, I think that's you know, extraterritorial effect is really issue is how you how the implementation, you know. So I think, you know, the concept, as Jerry mentioned, that is, well, that if you just, you know, for the purpose to selling the goods or provided service to Chinese customers, or, you know, you analyze the behavior of Chinese consumers, or you're dealing with the important data that may, you know, trigger this. But in reality, for example, you know, cross-border e-commerce, you know, people just selling this stuff, and you know, we just have a shop online, and you know, Chinese customer will visit, and you know, they will buy, and you know, so how can they abide by the law? And also, I think many, as far as I know, that many clients are waiting for this, because you know, on the PRPL, there's a system, you know, mechanism, as Jerry mentioned, that you have to have a representative in China and report, or you have to set up a entity, you know, to report to the authority, you know, how you manage dealing with those data. So I think in reality, you know, this could be very difficult. But if for many companies, they are focused on, for example, cross-border e-commerce, they're just, you know, selling products to China. China is their huge market. You know, they are very important market for their products. I think they may have to, you know, consider how to comply with it. For example, if they have subsidiary in China, or if they don't have, whether they need to, you know, cooperate with partners to have a representative.
Okay. So I think, you know, look, what I'm actually thinking is, I think the cross-border thing, or those kind of people selling, you know, via the big internet platforms, I think they're probably at risk more than people think, because I think the regulator won't go after the individual companies, you know, selling some cosmetics or stuff like that. But the big internet platform companies, I mean, there's been some new regulations about them as well, and they're very clearly a target. So yeah, obviously, if you want to like do something about protecting people's data, you deal with the people who've got the most data. You don't go after the people with an Excel sheet. So I could imagine, similar to how, you know, Taobao and JD, all those guys have those anti-counterfeiting things, and you need to show that you've got the ownership of the brand before you can go on their platform. I reckon there'll be a lot of self-governing, and you know, so probably Tmall will probably need to see that you've got data compliance in place before they'll let you sell. You know? So I think that's where people will get caught. So I think, Sana, just on that kind of extraterritorial effect, just briefly, what has the EU done to companies? Like, who have the EU targeted with GDPR outside of its borders? Who and what kind of things do they do? Because I think we know that they are similar, is what China.
Yeah, it is. It's exactly the same concept. And actually, it's always been a bit of a grey area in terms of, well, what counts as, so obviously selling goods and services, that's quite an easy one. But what does it mean about, you know, targeting somebody or behavioral kind of analysis, that sort of thing? And there were, you know, there was guidance that, well, if you merely got, for example, a news website, and your news website is primarily for say it's based in Australia and it's targeted at Australian people, then somebody in Europe decides they're going to go on there and have a look and have a browse, and then, you know, that's kind of incidental, so that wouldn't be caught. Has to be something a bit more than that. And that said, recently there was a fine levied by the Dutch Data Protection Authority on a website that was called Locate Family. Probably, you know, does what it says on the tin. So presumably there was quite a bit of personal data being provided on that website, where people were trying to locate family members, etc., or locate friends. And I believe, yeah, they were fined €500,000 very recently for not having a GDPR representative but operating in the EU.
But they were Dutch. So where was that company based?
I think it was a Canadian company.
Okay, and so just on the extraterritorial, so I guess like the EU, they recognise, is it New Zealand, and which other kind of countries do they recognise on?
Okay, so a handful of companies have adequacy, which are Japan, Canada, New Zealand, and a couple of South American sort of, so Andorra. There's there literally is a handful of companies. The US doesn't have adequacy status. And I mean, it will be interesting to see, for example, if China does enforce a very GDPR-esque law in future, could China get adequacy? That would be an interesting one. I'm not so sure, because I think as usual, these things are very politically driven as well.
Yeah. So I think, while I've got you there, Sana, one of the issues, one of the most sensitive types of data, I guess, is employee data. And, not everybody's a B2C company, but everybody has employees. So why is employee data so important, and how is it protected in the GDPR?
Employee data is really important because obviously when you have employees, you have HR information. So you have information about somebody's salaries, appraisals, performance, all of those sorts of things. And depending on the type of organization, you may even have more. So certain companies, depending on the role, may require specific testing. So you might need drugs and alcohol testing, or security testing, or criminal checks, etc., depending on the nature of the business. So obviously there will be lots of what we classify as sensitive or special category personal data. So it is really incumbent on employers to ensure that that data is secured and only shared on a need-to-know basis. And unfortunately, a lot of what happens is people, and managers are very commonly one of the culprits, although albeit not intentionally. What happens is, people talk about colleagues, employees on chats, messages, things like that. And it's just about being really careful about how you're disseminating information. And if you're sending somebody's appraisals or performance related or salary related information on email, for example, to ensure, that there's some sort of password protection or encryption or something. I don't know if you want me to talk a little bit about the international transfers at this point in relation
no, I think we'll touch on that in a second.
Yeah.
So
but the one thing I would mention, is that the GDPR does have an exception which allows employers to be able to process sensitive employee data without having to get consent. So I don't know if that is different under PIPL.
I think, Jerry, you might be able to shed light on that.
Sana, you have raised a very good point. Yes, indeed, we under the new PIPL come out this year, so we have the similar provisions specifying that companies as the employer, so they might have they might rely on the legal basis of so-called HR management to avoid the general requirements of consent to directly collect and process employees' personal data. It's not only the sensitive personal data, it's all the personal data. But however, to use such legal basis will require two preconditions. One is the company has to prepare a policy that has passed the internal democratic procedures, which is agreed by the labor side. So and all the relevant activities has to be carried out strictly in accordance with such public internal public policy. And the second one is all the activities using the legal basis of HR management have to be for strict necessary of the HR related matters. So this is only the provisions provided by the PIPR, but what we see from in practice that it's still not clear enough as to what extent that a company as an employer could rely on this legal basis to do the real data-related activities. So the practical suggestions at current stage we give to our clients is that it will be safe that the company still rely on the traditional like notification and consent basis, but only at this stage. So in future, there may be some more clarification as to the scope of so-called employees' personal data that the company could rely on the new HR management basis. So this is what we saw in China. Yeah.
Great. So I think, look, Sana mentioned before, but Atticus, I know that you've done a lot of work on cross-border transfers of data, particularly I think with B2B companies a lot. People doing joint research projects and that kind of stuff. How is the PIPL affected on that? What's been the impact on these companies?
Yeah, I think this maybe this issue maybe a lot of companies, especially as you mentioned that the multinational companies are very concerned on this. And so on the PIPL, I think there's a mechanism established by the law that first of all there's a threshold that has to be localized in China. For example, if you are a CIO, the CIO in China, it stands for critical information infrastructure operator. So if the company is a CIO, every personal information you collect in China, generate in China, it has to stay in China. So this is clear that has to be localized. And the PIPL also established a threshold that if the company process certain personal data reach a threshold, then this also have to be localized. So currently, from the drafts of the regulators, it seems to indicate that 1 million individuals might be the threshold. So that's has to be localized in China. This is the threshold CIO and also maybe 1 million individuals. And except for those restrictions, other not reach this level that you can transfer cross-border. But the PIPL offered basically 3 or 4 approaches for options. For example, one is mandatory assessment by the authority. The other is verified by the institutes recognized by the authority. And the other is, I think many European clients are very familiar with that in SCC, standard contractual clause. So that's the mechanism the PIPL offer for this type of cross-border transfer. So I think that's the kind of brief picture of cross-border transfer of PIPL for personal information. In addition, I also want to mention that currently the overall picture of China regulating data. In addition to personal information, personal data, there are also other non-personal data. Those non-personal data, for example, the important data. So as mentioned earlier, that China also currently, established those mechanism, to basically ensure that, if the important data, generally the trend is it has to be localized in China. So that's the big.
So I guess the issue is what data is private or whatever. So does that mean if a big company has got personal data, but it's no longer connected to individuals, it's just become statistical data? Can they still move that data around, or what do? Are they allowed to if you can't tie it to something, if they anonymize it or they make it statistical, can that data be exported?
And sorry, Atticus, could you just also tell us what is important data, or what's classified as important data?
Yeah, sure. So for important data, actually, the current law, the law in effect has not used but not defined. So basically, the important data is that those data, maybe if leakage, the damaged, or improper deal with or cross-border transfer will damage, jeopardize, or compromise the national security or public interest of China. So that's the general scope of important data. But currently, the only certain definition for important now is in the auto sector. So in auto sector, that the recent regulations just define this. For example, if it's related to sensitive areas, this geographic information, or is traffic flow, and also maybe the video, or those images containing personal information, or private car plates, or the and also there's a 100,000 individual information that will also constitute important data under the auto-based sector. So that's kind of sector-based regulation to define the important data. China now has for example, under the data security law, will establish a hierarchical a way to define the important data. The central government will have this outline, and the more detailed definition scope of importance will be defined on the regulator sector basis. So that's will be developed as soon as possible, but it is still in the process.
Okay. And so, but the data itself, if it's statistical or if it's not, if it's anonymized or it's pseudonymized, is that data okay to transfer, or is it still potentially problematic?
Yeah, I think that, Mark, as for example, if personal data is already anonymized, so this is no longer personal information, it will not be subject to the PIPL. But depends on what the type of data. For example, there's a great scope of important data. For example, in certain areas, in the pharmaceutical and also other sensitive area. For example, maybe gene or other sensitive areas that maybe impact of the security, national security of China, maybe be restricted by government. But general, I think if it's anonymized, then general, I think this not strictly restricted.
Okay, great. And so just talking a bit about like real things, very concrete. So Sana, I think the GDPR and also PIPL, they foresee, and I think Jerry foreshadowed it a bit with, even if you're operating offshore, you might need to have somebody here to act as your point person on data related issues. So Sana, are you one of those people? Do you act as the data person for companies, or has it to be somebody in the company, or what's the kind of roles and how important are they?
Yeah, so for example, in the EU or the UK, because now if you're operating in both, but you don't have a presence in the EU or the UK, as in you don't have an entity or a branch, but you operate. So for example, you might have a website that allows people to search for jobs or something like that, or something else. You might be selling something, but you don't actually have an entity or a branch in the EU and or the UK, but you're handling personal data from abroad, then you will need to appoint a GDPR representative, and that could be a company, a law firm, it could be, and then there are people that act as consultant GDPR representatives, and we do act for clients as their GDPR representatives, in answer to your question, Mark.
And do you have any liability? Is that role, like, could you go to jail if there's a big hack by one of these companies?
Thankfully, no. No, the idea behind the GDPR representative is you are the company's point of contact in the EU or the UK. You are, so if an individual wants to raise a complaint and that individual is in the EU or the UK, or they have a data protection related question, etc., then you are the point of contact for that person. They shouldn't have to try and have to deal with somebody cross borders. That's the point of the GDPR representative. And for the company, the advantage being that you have somebody locally on the ground that is familiar with the data protection regulator and how they operate. So it's not necessarily an advisory role. It can be, but it's more meant to be as a point of contact for the individuals whose personal data is being used.
So that, like that Find My Family, that Canadian company, would they have, was it they didn't have that person, or what was their problem?
They didn't have the representative. They didn't have a person or a body acting as their sort of GDPR representative, but they were operating in the EU, and they,
And if you were just acting, I mean, so you said the Netherlands jumped up in that case. Does that mean everybody in the EU could have jumped up as well, or they could all continue to jump up?
Yeah, it depends, because, you know, for example, recently on the WhatsApp fine, I don't know if people heard about that, but WhatsApp got fined 225 million euros recently for transparency breach, so not having appropriate privacy notice. And because they're based in Ireland, so it was the Irish regulator that led proceedings, but actually consulted with the other European authorities as well. So they do operate together. They consult and confer.
Who gets the money? I don't know if that's a question people know. Because it must.
Well,
it
we'd
would
all
be
like
quite
to know that.
Yeah, okay. But so maybe Jerry, what have you seen so far? So I think in China it's a DPO is the not the GDPR representative. They have the DPO. Is that right, or?
Yeah, I think there are several roles addressed by PRC law this year in terms of the internal roles requested by a company doing the data-related things. The first one is what we mentioned in the extraterritorial effect, that if for a foreign company, even if they do not have the substantial business in China, but as long as they process any data, the so-called triggered data in China, so there will be appoint the local rep in China. So this local rep is more like what Sana says, the function is more of like communication with the authorities. But apart from that, some other laws in China that they raised up some new roles for the internal management. First one is the DSO, the so-called data security officer, provided by the data security law. So this role covers the activities of non-personal data as well as the personal data. So it's a general data security role. So this role will be mandatory as long as the company involves any important data, and as well as the personal information of more than 1 million individuals. The second one is called the PIPO, is similar to what's required by the GDPR, is that the person specifically to take care of the company's activities relating to the personal information. So this PIPO the requirement of this PIPO will be triggered when the company handles more than 1 million the personal information of more than 1 million individuals. Apart from the data perspective, so about the cyber security things, we do have another two roles. One is the cybersecurity general responsible person. This will be generally required for each companies registered in China, because this is more of like to take a general responsibility of the company in terms of the measures, management, also the policies, documents relating to the cybersecurity things. And another one is as a second layer. So if any company is identified as a CIIO, the critical information infrastructure operator, so there will be a specific mandatory role called CSO, the cybersecurity officer. So to have more attention, to pay more attention on the cybersecurity administration matters. So this is the general background. But also I saw some questions asked by our clients that whether these roles is necessary to be internal or external person. So our answer is for the cybersecurity related roles, the cybersecurity general responsible person and the CSO, it's recommended to be internal person, because such personnel, the candidate must be very familiar with the company's cultural practice, internal policies, procedures, blah, blah, everything. But for the DSO and the PIPO, the answer is not clear in China now. So, because we learned something from the GDPR, because we know the GDPR might allow the external person like lawyers and other professionals to take care of these roles. And actually, the external vendors will be much more helpful to the clients at saving the costs to set up a regular role, and also like to provide more professional, deeper expertise or like advice in terms of the data or cyber specific matters. So we hope like the rules. We hope the like clarification of like whether the company could hire the external experts to act as the DSO PIPO for the company will be coming out very soon. Seems like early next year, since because it's close.
That would seem likely to me that the PIPL thing, it's a bit of just a contact point, like Sana said. But the cybersecurity one, because
Sorry, Mark, under the GDPR, there are also two roles. So there's the GDPR representative, which is where you have the extraterritorial application. If you don't have an entity or a branch in the EU, but you operate, right? Then the DPO role is separate to that. So that's data protection officer, but that's only required if the company has very large scale data processing, so regulated, for example, banks, etc., or if they're health companies, health organizations, or if they do large scale kind of systematic monitoring of individuals. So maybe big AI companies or advertising, online advertising, those sorts of companies, they also need to then appoint, even if they have branches or entities within the UK or the EU, so they could just be a UK company or an EU, they would need to appoint a designated data protection officer. So that's separate from the GDPR representative. They're two different roles.
Okay, so I think, so what I was just going to get at with the China aspect though, is I understand if somebody's just a point person for the extraterritorial, it's be a bit tough to like put them in jail. But if you're the cyber security guy and there's a big hack, is there a risk that those people might be liable? They might go to jail, they might be sued, or, in a personal capacity? Jerry, what do you think?
Oh, yeah. Theoretically, it is, because the PRC law provides some like personal liabilities against the so-called PIP or DSO or general responsible person. But in fact, we would consider this as a very extreme cases and with the very bad intention to violate the relevant regulations. So I think to answer your question, even though it's possible, it's theoretically possible, but it's somehow like a very extreme case in practice. Yeah,
we would probably say that about non-executive directors on listed companies until 2 weeks ago, where those guys who were earning 20,000 RMB a year suddenly got hit with hundreds of millions of RMB in damages claims.
Yeah.
They weren't really involved. So I just would think probably a law firm would be very, very worried about being the, being a point person's okay, but to really be responsible, it probably won't be good enough to say, oh, nobody told me, that's the kind of, that's a risk.
Yeah. Yes.
Okay, so maybe Atticus, just, since you're heading up the efforts in Shanghai a bit, what are you seeing? I know you guys are busy with, reviewing contracts, helping people get the stuff into place, and there's a lot of interest. What's the feeling? Are people implementing it? Are people still nervous, or what are you seeing on the ground?
Yeah, I think, people this time, especially for those data security and also the PIPL, because of the, serious punishments and, it could be very high economically. And also, as Jerry mentioned, there are also, personal liability for the kind of management and also the PIPO, or we call it a DPO. So people, I think now is companies take it seriously. But the process of implement the law, I think, is overall it takes time, because the law, the PIPL, just came into force not less than no more than 2 months ago. So the companies in China have less time to prepare to be fully compliant. In comparison, that GDPR they give companies 2 years to prepare, but the PRPL only give companies maybe just merely 2 months. So I think now the Chinese companies have a shorter time to get well prepared for this. This is one thing. The other thing I think now is on the PRPL and even another, for example, the CIO and also the important data, the scope of important data, all those structures and the framework has not been well established. Take PRPL, for example, on the PRPL, for example, cross-border transfer, and there has many ways for you to do, for example, SCC contracts and also verification by third-party institutes recognized by the authority. But currently, there's no implementation rules issued available yet. And also, for example, cross-border transfer. Recently, there's a draft, for mandatory assessments. But this has not been officially released. So companies are keen for those implementing regulations or rules to be in place. But in reality, I think it takes time. So we are our understanding for the client. Now they just adopt a wait and see attitude. But what they can do already. So for those parts, they actually already take actions. For example, the Chinese government is very keen to address those app compliance. For example, many apps, abuse personal information. So the CR, the MIT, the responsible regulator, they take a lot of actions to many, rate of apps. So for compliance, and also, for those websites and privacy policies, those obvious things that the companies take actions to make it updated to be compliant with the law. For some internal mechanism or system, the rules to be established by the law, it takes time because of lack of implementation rules. So that I think is a process, but companies watch closely on the progress and to be ready to be compliant with.
Okay, great. So look, I think that last point which we had on the slide, I think it probably doesn't really fit the flow. I know it was my idea to put it in, but I think Sean, did you have any questions? Because I think I think it's been a lot of information for people. Were there any questions from your side, Sean, or anything in the chat room which you saw? Which
yeah, I have one question here, and I think it's a pretty interesting one. So you mentioned earlier that you think that there will be a lot of self-regulating with respects to probably like Tmall and Taobao, that in order to sell on there, they would have to do some, I guess, KYC for the vendors to make sure that they do have some of these data compliance structures in place, just to kind of remove that liability from their side. The question in the chat was, do you think that it's practicable for these platforms to provide a presence in China for offshore vendors to enable compliance? And I would probably even go one step further, just to say how, like, just to expand upon your idea about platforms and how they play a role in their relationships with vendors.
So I think the reason there are specific regulations about the internet platforms, so it's really clear that they're the ones who are most regulated. They're obviously the ones which are the most under pressure or scrutinized. Look, I haven't seen anything about the self-regulations. Just that the PIPL allows various people to take action, even consumer groups. I think it would be very unlikely that Tmall or Taobao or JD or any of those guys would want to get involved in your data issues. I think what I'm thinking is they want to tick the box that they don't have hundreds of thousands of companies who are not got anything in place. So I think they won't do it. And the reason why I thought of this is it's the cosmetic companies. And so the cosmetic companies, if you have somebody entering the China market, you know, there's a lot of self-regulation. People don't really believe it, but a lot of cosmetic companies now manufacture locally within China. And so they'll have to get like a OEM, like a bottler to bottle it for them. No reputable Chinese company will actually do it unless you prove you're the owner of the brand. You can't like launch on Tmall Global unless you can show that you're the owner of the brand. So I think at some stage, it'll be one of the things that you have to show is probably that you have this contact person in China, and probably they'll say, can you provide us with information about how you deal with the data? Can you sign some documents that you comply with our requirements? Otherwise, they'll just bar you from their website. So I think, for them, if you look at it, it was about 5-6 years ago when they were called then the AIC, now it's the AMR. They had a big fight with Alibaba about counterfeit products. And that's when Alibaba started taking down all the counterfeit products. So I think those internet websites, they're much more interested in having a good relationship and not being seen as somebody that is an enabler of other people abusing information. And for the Chinese regulator, they're just sitting there in China, much easier than going after 500 foreign brands selling on it. So that's where I think it will come. I don't think the team, all of those guys will solve it. I mean, like, also you've got those TP partners. Maybe the TP partners will be the ones that will be willing to be your, point person.
Thanks a lot, Mark. I have one question. I think Jerry might be, this question kind of goes to what you were talking about earlier in terms of the HR exception to the employee personal information. The question here is the legal basis of the performance of contract, the HR management, is that a complete exception to consent? Or does that mean that there will that separate consent is not required for sharing cross-border transfer of the employee's personal data? I don't know if you mentioned before that that this was still being kind of ironed out, but what is the current status on this HR exception and separate consent? Jerry?
Yeah, I can answer this question. So this is actually a very good question, and we are frequently asked on these topics. Our clients, most of our clients are very interested in like applying for different legal bases other than the notification and consent. And they were excited about like contract performance, HR management, or even some like others like to avoid the consent matters, because consent will cause like the withdrawal of consent with the personal information data, subject rights, blah, blah, everything. It will cost very much effort in practice. But however, I have been keeping talking with the clients saying that we should be very conscious on applying the new legal basis because it's too new, because it's easily to exceed the so-called necessity scope of processing the personal information. So even if like some legal basis is obviously could be applied. For example, like if a customer is requesting a delivery of the products and the logistic company deliver the products in there. So even if in this obvious situation, so it might likely that the legal basis could be applied. But however, the scope is not clear, and also the practice is not clear. So what we advise, like the HR management things, is like we still use the notification and consent at this stage, maybe within several months, later this year or at the beginning of next year. So the answer will be very much clear. Yeah, this is kind of like a choice strategy in practice to mitigate the risk from the compliance side.
Thanks, Jerry. And I think Sana had a good point earlier about this too, is, sometimes for HR reasons, you might be collecting, data that is a little bit beyond just the normal personal information. It could be drug test related, other types of things, performance related. So it is important to kind of figure out what scope of this HR data we're actually talking about. There's one more question, and maybe Atticus, I can ask you. The question is about the process of appointing these internal roles. Like from a practical perspective, is this something like you just make a filing with the authorities? How does one go about actually nominating an internal role with the government?
So Sean, you asked me?
Yeah.
Yeah. So as Jerry mentioned, that there's DSO, CSO, and also PRPO. So there's different roles on the different regulations. So basically, I think currently there's for example, for the cybersecurity, the responsible person that it has to clearly that there's a responsibility or scope work to do for this role. But for example, for the PRPO, it's very brief, and there's only mentioned that they take care of the processing or handling of the personal information on the PRPL. So it's at a very high level, and also there's not crystal clear whether professional PRP DPO can be an option. So I think this also needs to wait and say whether there's implementation rules to make it clear. I think at this stage.
Great, thanks, Atticus. And I guess one last question for Sana, and this is just my personal interest. I mean, one of the reasons why we assembled this panel today is because there's a lot that we can learn from the PIPL by just looking at GDPR. So Atticus mentioned earlier that China seems to be taking, at least in some ways, a sector-based approach in determining what is important data and other and just going about defining data through a sector-based way. Is that something similar under GDPR, or is there also like as an example, an auto-based data regulation similar to what Atticus was mentioning earlier?
Okay, so a couple of things. So for example, in the EU and obviously UK now, the focus is always about the individuals and whether individuals are able to exercise their rights in full over their data. So it's all about transparency and allowing individuals to be able to exercise their rights. And so just for example, there might be a slight divergence. So based on that consent point there for employees, for example, in the EU and the UK, it's not seen as good practice to get consent from employees because it's seen as there's going to be an imbalance in the position between an employer and an employee. So if you say, I want your consent to be able to use your data, the employee may feel they don't really have a genuine choice. So on that basis, if it's so already in the EU and the UK, the practice is if you have another legal basis, you must rely on that rather than consent. So it'll be interesting to see. But in terms of the sectors, it is all about the harm that could result. So if you're an organization that's processing data in a way, or the type of data or the purpose of your processing is such that there could be a negative impact on somebody's data protection rights, then those are the sectors that are most at risk and that regulators are most concerned about. And that's why the likes of Facebook and Twitter and all these other big tech companies, because effectively they are seen as using a lot more data than your average kind of sort of some other sectors. But yeah, there will be. So for example, automotive you mentioned. So if now vehicles are pretty much computers on wheels now, so they may be collecting a lot of data, then the health sector naturally that they've got huge amounts of very sensitive data. But now you have obviously the usual kind of health institutions that we think about. You have hospitals and doctors, surgeries, all of those things. But now there are lots of apps collecting health information, just general. So you might even just have, something that tracks your steps every day, or, it could be very basic apps, but they collect information about your weight, your height, your, you might be your heart rate, etc., etc. That's all sensitive information. So it's just about being mindful about the types of information you collect and whether and ultimately what's the harm that could result. So it's not necessarily about sector, it's about the nature of the processing.
Great. Well, I think that's all.
We'll keep your drug test information private. I was going to send it to everybody, but we'll keep that private after I've been convinced. But I think that maybe, Sean, we'll close it up there because some people are leaving because of other calls. But I guess this will be the last one for this year. So just would wish everybody a Merry Christmas and a Happy New Year. Hopefully we'll catch up next year.
Thank you for putting up with us for a whole year, everybody. Well, that concludes it. Stay tuned. We're going to come up with some new ideas, and also upload this recording onto YouTube and send everyone the links. Thank you, Atticus. Thank you, Jerry. Thank you, Sana. Thank you, Mark. Happy holidays, and see you next year.
Thanks.
Thank
you. Merry Christmas.
Thanks,